Okay, I guess we'll have stragglers coming in, but we'll get rolling. We have an action-packed day of three segments. One on the role of chief restructuring officers in Canada and the use of them versus the U.S. A second segment on flashpoints in cross-border insolvencies in Chapter 15. And the third segment on the cannabis space, which I'm told is why everybody's here. We also have six distinguished panelists, or 5 plus me. And while you're eating, I'm going to do a brief introduction. I think almost everybody knows everybody in this room, but let's do some quick introductions. Over here we have David Cohen, who's a partner at Gowlings WLG, a firm of 1,400 lawyers and 19 offices worldwide. And thank you to Gowlings for providing the space for us today. David is the national leader of Gowling Financial Services Industry Group. His practice includes bankruptcy, restructuring, lending, distress M&A, corporate law domestically, and cross-border. David has served as the global president in 2016 and chair in 2017 of the Turnaround Management Association and chair of the Canadian Bar Bankruptcy and Insolvency section. David's career has spanned 3 decades with Gowling and a predecessor firm by merger. David is also ranked in Chambers Bankruptcy and Restructuring and Lexpert, is that how you say that? Lexpert. There's no French accent on that at all. Ranked in both banking, lending, and financial restructuring. Secondly, we have Aaron Hammer, who came up from Chicago for this. He's a partner at HMB and leads the firm's, wrong bio, give me a minute. Aaron Hammer has practiced law in the insolvency and restructuring arena for 25 years. He's a partner at HMB in Chicago and leads the firm's bankruptcy reorganization and creditors' rights practice. Vast experience and thought leadership in both the U.S. and cross-border corporate insolvencies. And his writings on that are available at his website at bankruptcyjock.com. Aaron recently completed the successful turnaround of Red, the Steakhouse in South Beach, Florida, not only as legal counsel, but as its chief restructuring officer and now as principal. And Aaron is offering free steak to anyone going to South Beach.
One free steak.
Yeah.
First one there wins.
Clifton Profit is a partner and head of Gowling WLG's Restructuring Insolvency Group, practicing the areas of insolvency, pensions, and employment benefits. Cliff advises and represents creditors, debtors, insolvency practitioners, and other stakeholders in all types of reorganizations, liquidation, realization proceedings. Also appears on behalf of his clients in the Ontario Superior Court of Justice, the Divisional Court, the Court of Appeal, Supreme Court of Canada, and various administrative tribunals, including the Financial Services Tribunal. Rick Ryan, also from Chicago, thank you. And HMB is a partner and group head of the litigation group. Harwood, Marcus, and Burke is what HMB stands for. I hadn't said that yet, so there you go. He is and at the end of these introductions, Rick, I'm going to ask you to say a few words on HMB, if you don't mind. He's a graduate of the Washington University in St. Louis, Missouri, and University of Miami, Florida School of Law, and a member of the Illinois and Florida bars. Rick concentrates his practice on secured creditor workouts and recoveries, bankruptcy, trustee, and receiver litigation, and multiple jurisdiction litigation and bankruptcy, specifically Chapter 15 proceedings, and the recovery of foreign claims and assets in more than 40 jurisdictions. In 2014, Rick was named Asset Recovery Lawyer of the Year by Lawyer Monthly magazine. Rick was recently honored in the 26th edition of the Best Lawyers in America for his work in commercial litigation. Peter Simeon over here is an experienced corporate commercial securities lawyer, again with Gowling WLG. Focuses his practice on corporate finance, mergers and acquisitions, and structured products. He has acted for clients across a range of industries such as cannabis, mining, and technology. Experienced in public offerings, IPOs, private placements, RTOs, qualifying transactions, bought deals, secondary offerings, share, and asset purchase transactions. 2019, Peter was named one of Canada's 25 most influential lawyers by Canadian Lawyer. I'm Scott Sinclair. I'm president of Sinclair Range. Sinclair Range works with companies in transition, including high growth and troubled companies. We provide turnaround advisory, interim executive, CRO, distressed M&A, corporate financial services, both as advisor and principal. And those are our panelists for today. And we're going to switch in and out with different panelists on the 3 segments and different moderator on the 3 segments. And with that, Rick, I'd like you, could you say a couple words on HMB, please.
This HMB, or Horwood, Marcus and Burke, is a single office firm in Chicago. We have about 65 lawyers, which is in Chicago mid-size, but we have a big firm expertise and knowledge base. We this year through September have handled 125 M&A transactions. There are about 10 of us doing litigation and insolvency work. We have a niche in international insolvencies and representing and assisting fiduciaries in recovering assets and claims around the world. And we appreciate being welcomed here by Gowlings and David to speak to all of you.
Thank you. Like I said, we're going to have 3 segments and a short transition period in between where we move chairs or people in the chairs. We'd like this as much as possible to be a discussion. So just ask questions as we go. If we've just started a segment, maybe, they're all scheduled for 20 minutes, so maybe 10, 15 minutes into them, save your question until then, if possible. But we're not going to do a formal Q&A afterwards. So just throw it out as we go. If you see something you want to talk about or ask some questions, would be great. Lastly, we're filming all of this, recording all of this back here for the Martinis with Scott channel. If you don't want anything being recorded, just say so. We'll cut it out in production. This seminar is for you. And with that, we'll start on our first. Sorry, you had something to add in there?
No, I get to start out as the moderator.
Yeah, so we're going to start on our first session here, which is the role of Chief Restructuring Officer, and on that will be Rick as moderator, and David and myself and Aaron.
So, CRO, or Chief Restructuring Officers, we thought we'd discuss the role of CROs in the U.S., the roles of CROs in Canada, how they differ, how they're the same, the benefits to increased use of CROs here in Canada, and the barriers to expanding to incorporate the way we do things in the U.S. And sort of adopting the U.S. model. So what I thought we'd do is start out with Aaron discussing the function of a CRO in the U.S. and how that role comes about and how the role is filled.
Thank you for that, Rick. Before I start, let me thank the folks at Gowlings, David and Lily and the rest of the team here, Cliff. It's been about 20 years since we met when you were at Smith Lyons, and it's just wonderful to see where Gowlings is today and to see where all of your careers and efforts have gone and all the people we've met along the way. And for that, I'm very thankful. Thank you for having us here today. And let's talk. My job's pretty easy. I get to talk about the role of CROs in U.S. insolvencies. It's an accepted role, and it's ever present. CRO might be a misnomer because at its core, you want a financial professional in the company reporting accurately and driving change. As a lawyer, without that person, you're left with your client who, or its lender, that drove the company into financial distress, or perhaps market conditions impacted the direction of the business. In my mind, a U.S. CRO or turnaround professional is a neutral, independent party. That person has expertise and experience in evaluating a business, ascertaining its viability, and plotting a course of action based on that, whether it's an asset sale, a refinancing, or in some cases, a liquidation. The sophistication of your, quote, CRO often depends on the circumstances. If you have, let's say, a big public company, and the market in the United States has sort of responded to that, right? So if there's a big public company that's in distress, there are the sort of big cap market leaders, McKinsey, Alex Partners, Alvarez and Marcel. Those folks come in generally in larger situations, often with a mandate from the board of directors to serve in an official capacity as chief restructuring officer. Other situations call for a different solution. If the situation is more middle market, there's a whole segment of turnaround professionals and financial advisors that are playing in that space, the Conway McKenzies of the world, the Getzler Hendrick, Glass Radner. And these are robust businesses that are providing consulting services to vast segments of the market. And then there's the regional sort of players. And the smaller situations are generally handled by more regional or boutique operations. If it's a $5 million top line business, you don't need a major firm. You need someone who has experience in financial insolvency, turnaround, and those types of related activities. So the smaller business failures or the like are generally handled by boutique firms that are more regional as opposed to national. To summarize, CRO is entrenched. They try to be a neutral party that can be credible to the creditors in the court. And while they're often, while lenders often suggest that the company bring someone in if there's a default or other deterioration, they aren't necessarily beholden to the lender. They aren't necessarily beholden to the company. They're there to provide independent advice, and we rely on that as professionals.
So just adding to that, CROs in the U.S., generally it's initiated by the secured creditor. They are the impetus for asking the company, more than asking, suggesting to the company that they need some assistance. And the secured creditors, however, are very cautious of showing some type of fiduciary duty or exercising fiduciary duty or control over the companies. So the secured creditors tend to suggest 2 or 3 names, have the companies interview the CROs and have the company hire the CROs so that there's that impartiality, neutrality that's maintained. And tends to be a successful way to understand and to get arms around how the business is functioning and what it needs to do in order to hopefully survive. So, Scott, can you explain how CROs function and the types of CROs here in Canada?
Well, I can give my perspective on the types of CROs that should exist and that do exist in the U.S. in my experience. But I don't think in Canada we make full use of the breadth of services that a turnaround advisor can bring to this. And the original billing on this segment was, do we use CROs enough in Canada? And if not, why not? And I think the definition of a CRO, the definition of what a turnaround advisor is in Canada, in my experiences, or from my perspective, is far more limited than it has been in the U.S. And to your point, I think succinctly you said, the CRO is to effect change, and that's what it's all about. And so from the way that I look at things, in our shop we've identified 5 different types of turnaround advisors. And I don't think you can have this discussion well without changing the word from CRO to turnaround advisor, because you're going to fit into the continuum of trouble somewhere, and hopefully you're going to be long ahead of a court-appointed CRO. And so I'll just walk you through my thinking on the 5 types, and then I'll talk about what I see in Canada versus what I see in the US. So the first one would be the turnaround CRO, and this is a true leader who steps into a company as an executive, not as an advisor. He brings vision, he changes culture, he tries through operations, an operational focus to start making money. This is not a restructuring insolvency type professional. This is an executive that can step in and start to turn around the business. So think P&L more than balance sheet, although you always have to manage your balance sheet, your cash flow, of course. And in my experience, this sort of individual or service is almost always required in Canadian mid-market and smaller businesses, maybe not so much in the larger cap, although it could exist in the larger cap as well. Type number 2 would be the exit CRO, and this is a similar service, but it's more of a keep your fingers in the dike while you create an exit. Sell the company quickly, refinance with a different type of lender or capital provider to create an exit for the secured lender. And this person, more than an operations turnaround person, ought to have a bit of an investment banking bent to them. They don't have to be an investment banker themselves, but they need to understand the process of both refi and sales and how to sell a troubled company. And that's a different person or a different service, a different shop potentially than the turnaround professional. Third would be the restructuring CRO, and this gets more to the mainstream of what I see in Canada, which is there's an insolvency process, and this CRO has been appointed to help management. The thought there being that management needs to focus on running the business so things don't go downhill, and the CRO is more experienced in formal insolvencies and restructurings and can walk the company through that. The fourth one I like to call is the our guy inside CRO, and this is often stakeholder driven, whoever the key stakeholder is, and they just don't trust management. They just want integrity, somebody independent inside, and if you were to list the things that were important to that stakeholder, that would be number one. And the fifth and last would be the consultant CRO, is what I call it, and this is the idea that if you had better number crunching and support for management as an advisor, that management itself would affect that change that you referred to. And so my experience in the use of CROs is that in the US, you've inherently, maybe not in those words, but you've adopted all of those roles, and the specific file on which type of CRO you need, I mean, it depends on where they are in the continuum of trouble. What are the restructuring options? What's the sophistication of existing management? Liquidity, the size of the deal, public versus private. There's a million things that drive what type of CRO you have, but you can see from what I've described, hopefully, that not one firm can provide all that level of service or those different types of services. So I just think there needs to be a lot more thought about what is it you're trying to get out of a CRO, and what are they providing to this company to affect change.
So David, I hear how CROs are expanding the U.S. model in Canada would be helpful, but are there barriers to doing that?
I just talked. It seemed to work.
Oh, okay. I mean, there aren't particular barriers to the appointment of a CRO in Canada. For the most part, this is a pre-filing exercise normally. You don't normally see a CRO appointed as just a part of a court proceeding. It's often in the long lead up to a proceeding that you're trying to bring somebody in to affect change in a company. And so it's a matter of contract between the debtor and the CRO or the turnaround management professional. And so that's a question of, and actually that's where a lot of the nuance comes in Canada, and where you run into the difficulty. The major secured creditor may have a relatively high degree of skepticism around the quality of management because of the breakdown. There's usually a breakdown in communication. There's usually a little bit of hubris involved in how they approach the secured creditor from the debtor's perspective. And so the lenders out there look at it and they say, we'd like to have a change in management, but they don't necessarily know how to affect it well in Canada. And it's a problem because you walk in on the first day and you look around and you see a whole group of managers that, you see a weak CFO, you see a CEO with hubris and self-dealing, and you look at it and say, I'd like to probably change it today, but how do I do that? And outside of a proceeding and outside of exerting financial pressure on them. How do you affect that change? And what you see in Canada, which you see less of in the U.S. In the U.S., there's an appetite to walk in on the first day as and lenders, and they slam their fist on the table, and they look at the people and they say, "You got to go, or you need to step aside, or this company's not going to survive." And that's easier in an environment in the United States, I think, where you don't have owner-operators and you don't have because our mid-market is much smaller than the U.S. mid-market. You're dealing with family businesses. You're dealing with first or second generation ownership of a business. You're not dealing with professional managers who've been brought in. And so there's pride of ownership associated with it. So displacing the leader of the business is like taking the founder of the business out. But sometimes that's exactly what's called for. And I think that the Canadian experience has been, unlike the U.S. experience, very hesitant to take that step early on. And in fact, realizations could be higher and there could be more businesses saved if you take that step. You don't have to call it a CRO or a person a CRO. You just have to have, I mean, we've had some recent cases where we've gone in as debtor counsel in companies with very proud management and with a financial institution that was nervous about the circumstances and had a lack of trust. And as debtors counsel, we actually brought in a financial advisor who became the whispering ear to the CEO and created a whole text to the lender that solved a problem that otherwise was heading to an inevitable liquidation. I don't know that that's done that often. Usually when debtors counsel get involved, they're often looking at it as a defensive posture and they're trying to push the bank off as opposed to finding a way to build a road and a path. And it's what you talked about, Scott, which is arriving at that circumstantial guarantee of trustworthiness that you're in it just to help the business survive. And you're not on this team or that team, you're on the side of what's right financially for the company. Getting a debtor to that point and getting a lender to that point where they trust each other often takes one person in the middle of that. And that turnaround manager, that professional, is the linchpin for that.
So one last question, then we'll sum it up. But I'm curious, in the U.S., we can have appointments of U.S. trustees. They generally don't get in the way of a CRO or how the business is functioning. But under the CCAA, is the appointment of a monitor, does that create an impediment?
Dueling professionals sometimes, in a sense. Look, on the really large cases, you can often see a CRO. There was a CRO in the Air Canada proceedings. In some of the larger proceedings, you will see somebody brought in as an interim CEO with more restructuring experience to manage all the stakeholders effectively, and the monitor is just a monitor, the court officer, and it's facilitating the court officer's process. In smaller cases, what you see is an expansion of the monitor's role to be the super monitor, will be the CRO, in fact. And I think that's expensive because that's a lot of people doing the job of one person, potentially. And I think that it puts the monitor in an awkward position of actually having to take more strident postures on business issues as opposed to being just the court officer. And I think that the division of those roles is actually more important than that, and that we may have lost our way a little bit in Canada on the overuse of the super monitor.
So Scott, to sum up, I heard from you what there is today. What about tomorrow? What is your expectation, projection?
I don't have one. I don't see anything changing rapidly in the marketplace. We've been doing this broader turnaround advisory. I think we're unique in the sense that we don't do any insolvency work at all, right? We use it as a tool, but we're a going concern solution, and we're working for the debtor. And there's just not much going on in that space in terms of competitors to us. I'm not saying there's none, but it's still very unique in Canada, whereas the U.S. we're not unique.
So I think there needs to be more acceptance of that service for things to change in Canada, would be my expectation. I don't know, maybe you have a better perspective than I do, but that's what I see.
Yeah, and I mean, I would add to it that, I mean, one of the benefits of having spent so many years at the Turnaround Management Association was I sat in the middle of the largest organization of, turnaround professional CROs on the planet. And what becomes really, really clear is, and this all sounds like motherhood, right? Everybody knows this, but it never happens. The earlier in, the better, right? And so there's what you didn't really speak about in the CRO roles was actually this concept of early advisory services. You've got some breakage, you can see some covenant issues coming up, and instead of waiting until it's broken and you're having the bad conversation with the financial institution, you should be curating that conversation by having months of preparation in advance with somebody with the skills of a turnaround professional to guide you through that process, so that when you present the package of problems to the institution, you also have a solution. I mean, what is it they teach us all in when we practice law or in our accounting practices? If you're going to go tell people that they've got a problem, you really should go with a solution in your hand, or at least an idea where the solution might be. And the number of times that debtors come to lenders with no solution in hand, but just saying, well, we're working on it, and haven't thought about cash flow, haven't thought about next steps, haven't really engaged anybody here, talking to their auditor, which is great, except those people do not have the skill sets for turning around a business. Maybe some of them might, but for the most part, my experience is that they don't. And maybe they're running a sale process for one division when they should be selling a different division. They just have no idea where to start. And the mistakes that are made and get set in concrete before the special loans folks come on the scene. By the time it gets to that stage, it's reasonably broken. And so out there to the accounting firms, because it's your clients that are in this trouble, getting it transitioned earlier to you folks in your business is better. And bringing in an individual who can actually move the mindset of the leadership of the debtor earlier is better.
Thank you all. We're going to make a quick panel change and get into the flashpoints in today's cross-border insolvencies. It will be more of a panel discussion than using the moderator. We want to introduce Cliff
I think you've already done it.
to the panel, and the three of us will carry
Thanks,
on the conversation.
Thanks, Rick. I'm going to kick this off with talking a little bit about the current state of Chapter 15 in the United States, the actual proceedings themselves, and what the foreign representatives are intending to accomplish in those Chapter 15 proceedings. We put together a cheat sheet here for you all, so that you could see what the 7 Chapter 15s that have been filed in the United States this year sort of look like, and what they're intending to accomplish. I'm going to skip ahead and presume that everyone has knowledge of what Chapter 15 is, the vehicle for ancillary proceedings in the United States. Most often, Chapter 15 is invoked by a foreign representative in Canada, either a receiver or a monitor. They come to the United States, open a Chapter 15 proceeding, and seek to affect some outcome, be it, let's say, liquidation of the assets, enforcement of Canadian orders regarding settlement or claims reconciliation. The purposes are targeted. The scope of the relief in Chapter 15 is both explicit and implicit. Sometimes the greater power comes when the foreign representative is speaking from the center of main interests of the company. That carries more weight than like a Bahamian trustee over some kind of trust. Anyway, about 10 years ago, for one of the fine financial institutions in this room, with Gowlings and Richter, now Richter, we filed the first Chapter 15 proceeding in the state of Wisconsin. And the purpose was to affect a sale process up in Canada and to bring it down and have it simply and easily recognized in the United States under Section 363 to get a vesting order, sale of the assets free and clear of liens to a third party, but to do so in as efficient a means as possible. And we did exactly that. It hadn't been done before, but the judge was very accommodating, and he allowed us to rely on Section 363 in giving us the free and clear order based upon the auction process and the activities that took place in Canada. So because of that, we were able to bypass establishment of a stalking horse, a bidding procedure process. That whole sort of framework we were able to avoid. And it's wonderful, it's fulfilling to see that sort of framework has been adopted and carried on by other Chapter 15 courts. Kodiak Services is the most notable recent one, filed in March of 2019 in the Western District of Texas, a provider of wireline services to the oil and gas industries, operating in northern Alberta and British Columbia, Canada, and Midland, Texas. Receiver was appointed under the BIA. That foreign representative conducts a full-blown asset sale process within the BIA, supervised by a Canadian court, and then the foreign representative comes to the United States and successfully seeks recognition of a Canadian sale order in the United States. The foreign rep is authorized in this case to hold asset sale proceeds and distribute them per the Canadian approval order and further orders of the court. So the U.S. blesses the sale based upon what happened in Canada and the entry of a sale approval order, and authorizes the foreign representative to effectively deal with the funds up in Canada. That's pretty remarkable, and it is evidence of further pushing the envelope of the things that you can accomplish in a Chapter 15, generally directed towards efficiency and speed, right? So when you think of Chapter 15, think of me, but also think about efficiency and speed. That's what you're trying to accomplish in these 15s. Berlin Poulin is a interesting case. Now let's skip that one. Broadcast Systems Equipment. That's a good one. That's an Illinois case. And here, it was predominantly a Canadian business, and there was a BIA, and the receiver sought to marshal the debtor's U.S.-based assets for distribution to creditors in a Canadian proceeding. And here, the only issue was that BMO held the funds. There was no real connection to the United States, but BMO held the funds in the United States. And in order to release those funds, they asked for an order from the U.S. court, basically authorizing them to act in accordance with the Canadian court, given the absence of a concrete jurisdictional link in Canada. And it was a simple case. The answer was yes, of course. Here's your order. And there you see, filed in April 2019 and July 31st, 2019, the case is closed, which is sort of a remarkable thing. Discrete issue, bang, they got it. Cliff, you want to jump in and talk about some cases you've worked on?
For sure. I'd also like to take you up, Aaron, on, I think, some of the themes that you've highlighted about the exercise of Chapter 15 jurisdiction in favor of incoming cases from foreign main proceedings, particularly incoming Canadian cases. I think listening to you, what you were saying resonates with my experience. What you get out of the authority that the bankruptcy court in the U.S. is now willing to exercise under Chapter 15 is expedited and targeted relief for an incoming foreign main proceeding from Canada. And in every case, the cases you've mentioned, the ones that our firm has been involved in, we've been able to take advantage of that. The 363 type approvals that piggyback on the process from Canada and effectively give it full faith and credit are an extremely useful tool. You mentioned our early case in Wisconsin, which I remember, the first Chapter 15 receivership. Well, I can't get enough of a good thing. We did it again in Delaware, and we had a similarly excellent result, having the recognition of a Canadian-made approval investing order. All of those Canadian orders, of course, end with the similar paragraph. It's boilerplate, but it means something in the U.S., where the Canadian court, at the end of its order, asks for the aid and assistance of foreign courts and tribunals and for the recognition of its orders. Usually we just think, oh, well, we'll see what happens, but we don't think that when we have a need for relief in the U.S. and where we have particularly a need to deal with assets in the U.S. So the exercise of jurisdiction in hybrid, I'm using an informal approach, but really hybridized 363 approval processes in the U.S. to deal with U.S. assets and to give a purchaser the comfort of a vesting order and of a process in an expedited way. It can't be underestimated as a tool. And so, as a species of incoming cases, that's a really excellent thing that we all have in our box in Canada when we're dealing, as we do, increasingly, with the integrated nature of the businesses that borrow money from our institutional lenders and that carry on their affairs on both sides of our famously long, still undefended border. Why, though? I mean, the question that arises, how can this all work other than, well, it's written down in Chapter 15, or it's written down in Part 4 of the Companies Creditors Arrangement Act, or it's written down in the international insolvency provisions of our Bankruptcy and Insolvency Act. What's the basis for all this? And in some of the notes that we were discussing before we began this, I think, of course, you hit on it by asking a question. Under standard common law rules, which exist on both sides of the border, relating to the comity that courts of competent jurisdiction are supposed to provide to each other when the systems sort of recognize each other, like waving across a barrier. Under those notions of comity, you asked the question, I think, properly. Can you still go to a U.S. court and ask for the recognition of a particular insolvency order or outcome coming from Canada? Or does Chapter 15 cover the field? And we have not yet asked, differently in the U.S., you have asked this question. In Canada, after the promulgation of Part 4 under the CCAA dealing with recognition proceedings and incoming foreign proceedings, does comity still apply? Our Supreme Court began in insolvency the whole comity story, not comedy, but comity, with a case called Holt Transport Systems. And I think the answer, and I know the jurisprudence is mixed on both sides of the border, both sides of the road, I think the answer is that comity has been codified. The notions of comity are why the legislators and the courts applying what is now the new legislation in 15, not that new, and in Part 4, why they're comfortable in applying that legislation in a way that achieves targeted and expedited results. Because behind all that, the history of that for the courts and for the legislatures is this idea of comity. And comity in insolvency between the U.S. and Canada, I think, prior to the enactment of these provisions, was really at the high watermark for any sort of system. And that's not a radical statement. I mean, if Canada and the U.S. can't get their basic commercial laws together and their courts to cooperate with one another and to really give effect to one another's pronouncements, then there's no hope for international law of any type. So I think the reason why the good outcomes that we both agree occur when ancillary proceedings are taken either under Chapter 15 or Part 4 is because underneath that there is a spirit of comity, and the courts know that. And that's why in Wisconsin they'll recognize our vesting orders and our processes without necessarily looking into it the way a U.S. court would. And that's why in Canada, if Cole Holdings comes here to look for a claims process recognition and a plan approval, they're likely to get it.
So let me expound on that a little bit, Cliff, and talk about what's happening in 2019 vis-a-vis application of comity, whether there's the necessity of filing a Chapter 15 initially. There the case law I'm going to suggest is not as mixed as suggested. And there's one case in New York that came down in February. It involved EMA GAR fund. And in that case, in Canada, there was an approved plan under the CCAA, and the company was allowed to reorganize. The plaintiffs didn't participate. Then they filed a securities law action in New York. And the courts saw that they wanted to apply comedy. So they jumped to the comedy issue right away. There was no Chapter 15 petition even filed application, and said, sorry, you can't pursue, and we're dismissing the complaint because you should have contested the securities action in Canada. That case, I think, is the outlier. All other cases in 2019 have required a Chapter 15 proceeding to be filed and then get into international comedy. The other, touching on what Scott was saying, filing a 15 in the States is strategic. And it's strategic to take advantage of the way U.S. bankruptcy laws allow us to practice in the States vis-a-vis here in Canada. First of all, our discovery powers are much more expansive. It can be a free-for-all. And under Chapter 15, you can get discovery pre-acceptance of the Chapter 15 petition. Post that, you can take advantage of discovery under Chapter 15 or under Rule 2004 of the Bankruptcy Code. And even though the Chapter 15 cases provide that the representative needs to request the discovery, there is case authority that says just because where they contested the discovery, saying that the representative in whatever country he or she was wouldn't allow it. In the U.S., the courts are much more open and say, if you're allowed discovery here, we're allowing the discovery. We don't have to follow the laws of the foreign country. The other case I want to point out that just came down and in the spring of this year, and it's a remnant of Madoff, but it opens up the playbook, so to speak, for a representative. And what that said was, if a fraudulent transfer of an asset emanates from the U.S., the initial transfer, you, representative, can go seek to recover it on a worldwide basis. And it doesn't matter where the asset is, the jurisdiction emanates from the fact that it left the U.S. And so in the Madoff case, they're now charging after assets that went to the Caymans, went to Hong Kong, et cetera, to feeder funds and so on, because the starting point was in the U.S. So for foreign representatives here in Canada, if there's assets that were in the U.S., it opens up a capability to go pursue collection of that asset elsewhere.
Did they use a 15 in that case, or
They
no?
did no,
Right,
they did not use a
right.
15 in that case.
Talk about that a little bit.
Right. So what it allowed was the representative just to file the lawsuit.
Survived a motion to dismiss,
Correct.
right? Any questions? Any case, hot topics people want us to talk about here? I know we want to save time for the in-demand, highly popular cannabis
Slightly
program.
more invigorating.
Yeah.
Just a quick question. You talked a lot about recognition of sale orders and such. What about dip charges? I mean, has that been?
Same thing. I didn't see any in these cases that filed in 2019. There were about 20 cases that have Chapter 15s in the U.S. so far. But if you go back, I'm sure you can find it. Same sort of line of thinking, right? Outside the ordinary course of business transaction, So without having to commence a full-blown Chapter 11 proceeding to get DIP approval et al., you could ask for recognition of the foreign financing order if it's consensual. If it's not consensual, if you're trying to prime, maybe there's an issue there. There's a fight to be had.
In fact, in SRL Goma, under Chapter 15, the Deutsche Bank-led DIP that was very U.S. style, that was first approved, though, in Canada with the assertion of the Center of Main Interest jurisdiction, was subsequently approved under Chapter 11 by the U.S. Bankruptcy Court, and it was opposed.
In a 15?
In a 15. It was a 15.
So what happened?
But they held a full
Wait,
hearing, they held a full hearing and had
They did.
the argument among the creditors.
That's correct. So it was a full hearing. It was Chapter 15, and it was successful.
Yeah, truthfully, if you look at the sort of the controversy over the intertan dip, if people remember the controversy over the intertan dip, I don't think there's going to be a big distinction between, a Chapter 11 and a CCAA proceeding, and how the U.S. court or the Canadian court perceives a cross-border dip and the approval. I think if you've got creditors' rights in a different pool of creditors in the United States being affected by a Canadian dip order, there's going to be a hearing and there's going to be a fight about it, and it's going to be the same as and they're going to apply the U.S. rules to the process, right? I would have thought. I can't see them not doing that. It's not so prejudicial otherwise.
It's consistent with the way we've operated before and probably into the future. All right, we're going to make one quick panel change. Bear with us.
I like it. Do it. Unlicensed.
I don't know if people can read this. There we go.
David's selling a greenhouse, unlicensed, multiple. All right.
It says greenhouse for sale. Brand is thrown in free.
We're moving on to the cannabis segment. Miraculously right on time. This is a cross-border seminar. We all know as Canadians, there's not much cross-border activity in the cannabis sector. I
beg to differ. I think there's an awful lot of it. It's just
but
all
there's-
illegal.
We have 27 Canadian companies with U.S. operations, an additional 7 if we throw in hemp, so call it 34 that we were able to find. A good chunk of those are U.S. operations with a Canadian listing and therefore a head office. And we have another good category would be like a Harvest One that is a Canadian cannabis company with U.S. operations that really have nothing to do with cannabis because it's illegal there. So there's not a lot of cross-border is point number one that I want to make to set this thing up. And the other point I'd like to make that we all know in this room is there's really been no activity in terms of workouts or restructuring in the cannabis sector in Canada because it's been an equity play, right? There's been lots of money on the street. It's all been done with equity. So you either didn't raise money because your business plan was bad, or you're flush with capital and your business plan may still be bad, but you haven't run out of money yet, right? That's the sort of what we know about the cannabis sector in Canada right now. However, there's more debt being used. There's a shakeout of winners and losers. And, in thinking about this topic, there's some significant cross-border concerns that we'd like to talk about today, and one interesting cross-border opportunity that we talk about today. So with that, just as a setup, Peter, I'd like to start off with you and just talk about, you're doing the M&A on this, the financings on these deals every day. Would you just give us a state of the industry from a capital markets perspective, the increased use of debt, and what you see going on? And as a reminder, you've got the BMO syndicate on Aurora, which was an add-on I think you've got 3 out of the 5 banks on that, and top of my head, it was about 400 million, mostly term. And we've counted in Canada 359 public offerings, private placements in the last 12 months in Canada, of which 25% were debt. So there's some stats for you.
Yeah, thank you. So medical cannabis for medical purposes has actually been legal in Canada since about 2001. It wasn't until about 2013 where the ACMPR came into force that companies started thinking about going public. A lot of the licensed producers went public, raised equity capital, as Scott said. The first few years was really just the Canadian producers doing that. The last couple of years, you've seen a lot of U.S. companies listing in Canada. We've seen a lot of international companies listing in Canada. Primarily the first 3 or 4 years, it was equity. The last couple of years, we've seen a lot more debt, particularly in the last 6 months, given
Convertibles, right?
mostly convertibles. Although I have seen some pure debt deals as well, but mostly convertibles. The last 6 months, the market has corrected a fair bit in Canada, so the equity prices have come down. And I think that's led to actually more debt offerings. Companies don't want to raise money at a dilutive level. And frankly, investors, I think, are getting a bit worried. So they want to be, in front of the common shares and be ranking first. Most of the companies are still fairly cashed up at this point, but they're also burning a lot of cash. None of them are profitable yet. So, when the monthly burn is that high, you'd expect in the next 6 to 12 months, unless the markets recover and people can access the equity markets again, for there to be some issues for some of these players, right?
Sounds a lot like the dot-com bubbles, actually, if people remember that round for Silicon Valley and what happened there.
How much distressed M&A are you seeing?
So we're not seeing a lot of distressed M&A. We're seeing a lot of opportunistic M&A in this market, where people think things are undervalued. You still see a discount in the U.S. because of the the regulatory perceived issues, in my view, but they're still cheaper to sort of go acquire cannabis assets in the U.S. than in Canada. We're not seeing anything that's distressed yet.
There's an assumption, I think, on Bay Street that, and in the professionals, that the capital markets are drying up a little bit for cannabis. Whereas I think the stats are, in fact, that on a dollar and transaction basis, we're higher in 2019 a little bit than we were in 2018. And I think what's happening is the blockbuster deals are gone, but the mid-market volume is way up. Is that a fair comment? You would see that in your practice, I think.
Yeah, I think that's a fair comment. We're still seeing a lot in the mid-market. I expect to see a lot more M&A in the next 6 months. Frankly, a lot of the mid-market second, third, fourth tier players are likely going to try and merge to compete with Cannabis and Auroras of the world, right?
Yeah, and they've got the capital and the market cap to buy everybody and see what works out, which has been their business plan, right?
Definitely.
For this group, what's the size of a mid-market transaction?
So in Canada, it's probably anywhere from sort of 20, 30 million to 200 million, right? Like that's, in my view, the mid-market in Canada. In the U.S., is probably the low end of the market, but here that's likely the mid-market.
Yeah, I agree with that. We haven't seen much on the restructuring side. The two real trouble things that I can think of are CanTrust and Ascent. So David and Peter, whoever wants to take this, can you comment on what you've seen and the lack of activity and the regulatory angle of this? And I just, as a setup, I think it's everybody's view that there's going to be restructuring requirements in cannabis, within whatever, the next year or so, driven by an increased use of debt, winners and losers and shakeouts of the industry. And what's interesting is there are significant constraints to a typical restructuring in this business, both in Canada and in the U.S., but for very different reasons. So if we can start on the Canadian side,
So
David and Peter.
On Canfor, I mean, everybody remembers the picture of the CEO of Canfor standing in front of the wall. CanTrust. CanTrust, standing in front of the wall. Did I worry you? They're a borrower. CanTrust. He's standing in front of a wall, which was a false wall, and there was an unregulated, unlicensed grow op behind it. And they had their license pulled. The consequence of that was a collapse in the market price of the stock. And
They had about $1 billion market cap, and They were under $2 yesterday. I think they were $1.98. They closed, something like that. So that would have been 200, 250. And they're going to zero, near as I can tell.
Yeah, there's really.
At least that's our position on the stock.
So I mean, what do you do in that scenario, right? You don't have a license, you can no longer operate, you don't have any future. There's no trust in management. We could go out. You did a great piece on Martinis with Scott on what they didn't do in terms of crisis management, and so I think that they're pretty much a lost cause. The second case, the license was terminated before the CCAA filing. E&Y is in as a monitor, but what do they have to sell, or what do they have to restructure? Is the open question, and that goes to the heart of the problem in Canada, which is these licenses are non-transferable and site-specific, and
people specific.
And people
all three.
specific. Sorry, yeah, and so that's why I put this sign up, because you have this lovely greenhouse and this brand, and that's about the only thing you can sell. Because you can't sell a cannabis operation because you don't have the license, and you have to a licensed operator with a personal license who can come in and actually take over the facility has to have the facility relicensed. And Health Canada's phone is off the hook. In what was the comment in the monitor's report in the
E&Y monitor's report is that the company hired a regulatory consultant to make a submission to Health Canada and never received a response.
So yeah, Health Canada's response was absolute silence. So the people in this room all are familiar with sort of restructuring in the healthcare industry, and if you look at things like nuclear medicine clinics, X-ray clinics, long-term care homes. Those licenses they're not site specific. They're specific to the equipment, and they're specific to an individual. So when you go into restructure, and people in this room are familiar with this, when you go into restructure an X-ray technology clinic chain, you end up having to keep all of the technicians or the doctors in place who have the licenses, or you might as well hang out a shingle and say out of business. We don't even have that here, right? You can't go get another licensed operator. If you had your doctor and your X-ray technology who had the license leave the clinic, you might be able to get another licensed person to come in and care for that clinic and be the custodian of that clinic. But you in the marijuana and the cannabis business, that's not even an option. So where do you go? How do you restructure? You're a greenhouse sale business, and the brand has gone to zero, right? Because there's no market for it.
And to put some color on that, Peter, if you go back 2-3 years in your mind to the days of greenhouse tomato farmers with a greenhouse converting to an LP, a licensed producer, I was working on one in Leamington where it was worth nothing, 680,000 square feet. It was insolvent, and about 6 months later, I had an offer for $150 million. We weren't growing anything, right? It was based on the greenhouse. So just to give you some color as to the discrepancy in value between having a license and not having a license. If you don't have one, what do you sell? To David's point.
I agree. I don't think there's a lot of value in the greenhouse. So the problem is if you can't restructure and keep the license, the creditors are going to frankly not get back what they put in because the greenhouse itself will not be as valuable, right? They'll sell that for a fire sale. It'll take a long time to get it relicensed. They'll probably have to go to one of the larger LPs, frankly, that's going to be able to get that relicensed with Health Canada on sort of a more aggressive timeline, and it'll be for fire sale prices.
But the current greenhouses, the production, the planned production of the big players in Canada for 2021 is almost 3 times, not quite, between 2 and 3 times the demand.
Yeah, no, they're
why,
coming.
Why am I going to buy your unlicensed greenhouse?
Yeah, a lot of production's ramping up, right? Like the whole supply issue at the moment is in everyone's face, and so all the producers are ramping up new supply for next year and the year after. And so I agree, there may not be any sort of appetite for other greenhouses.
Okay, so the problem in Canada, to recap, is regulatory. That's a large one in my view. Aaron, the U.S., we have a situation where I think all but 3 states have to some degree legalized cannabis. Some are just medical, some are, a free-for-all. But it's not legal nationally.
That's right, Scott. And I have to say that I never thought that I'd live in a world where we were having this discussion. And the Canadians have sort of driven it, and I think personally it's the most appropriate response. And I'd like to see it continue to succeed. And I think Americans are with you in terms of the populists. The recreational use of the use of marijuana for medical or recreational is illegal under federal law. Marijuana is a Schedule I narcotic with cocaine, heroin, high-level opiates, and it's like, the hippie era is over. They won, maybe. Anyway, the U.S. is responding slowly, and my state of Illinois earlier this year legalized recreational use and sale, and that'll begin on January 1st. We'll be the 11th state in America that allows for recreational use of marijuana. I will add that you're starting to see, at least we've seen it in Illinois, some municipalities opting out of that and saying not in my town. Others,
Which they do through a zoning
they do through,
ban, right?
They do through zoning. Yeah, the legislation itself provides for the feature to effectively opt out if you're a municipality.
Not within 50 miles of a school, and there's 4 schools in the center of town, and the town's 2 miles wide.
I will add that there's different purposes for legalization of recreation for recreational use. Illinois, we have a huge budget deficit at the city and the state level. We're effectively bankrupt, and we need the revenue. Like Colorado generated some obscene amount of tax revenue, $250 million of cash, and that's all going into schools and related causes.
It was announced, what was that article a couple of days ago, that Canada lost money?
Canada
Lost money. The Canadian government lost money on cannabis sales.
by not enforcing taxation.
What was that? Yeah, exactly. Aaron, what is the impact of it being federally illegal on restructurings?
You have no access to the bankruptcy court. That much is clear. If you are a producer or seller anywhere in the
Direct participant.
any type of direct participant, you can't access Chapter 11 or the federal bankruptcy system to restructure, reorganize, liquidate. The remedy in this case would be you'd have to look to sort of state law and like an assignment of the benefit of creditors or receivership. The United States trustee, the Office of the United States Trustee, has been given a mandate by the Department of Justice to strictly enforce the illegality of marijuana sales in blocking the availability of producers to access bankruptcy. But it's also been expanded, right? And they're objecting to otherwise legitimate cases or fair cases under federal bankruptcy law. Here's one, Olson, District of Nevada, dismissing debtor's Chapter 13 petition because she received rental income from a marijuana dispensary despite recreational use being legal in Nevada. So there's a woman who files for personal bankruptcy and is precluded because she rented piece of property to a seller, and income she received is fruits of the poisonous tree, and no personal bankruptcy for you.
If I can just enforce that point. So if you're a lender and you're lending to a portfolio of commercial real estate, and that commercial real estate has income that is from a state legal cannabis business, you can be precluded that company, that borrower can be precluded from using federal bankruptcy laws, correct?
Let's put that into the context for a Canadian lender. Canadian lender is lending to a Canada-US real estate development business that has tenants in the US and in Canada. Among the tenants in Canada are a cannabis business in Canada.
Yeah, that's true too.
Right? If you extrapolate from that order, then if you try to bring a proceeding in the United States to reorganize that real estate company in Canada, and you need an ancillary proceeding in the US to effect it properly, you may be denied relief on the basis that you're undertaking this. If you have a lease if they're leasing particularly in the US to a US cannabis outlet, that's an easy, you're out of the box and not able to use a federal statute to reorganize.
The answer would be that you go to the Illinois State Court and you say, here's my Canadian order, enforce it, it's consistent with public policy.
Right.
You just don't get the benefits of Chapter 15 and then, you know,
Right, you
it
have
may,
to work around it.
right? So a couple more.
Hang on, Aaron, I think Jeff had a question.
I just had one question, like with respect to the one example that you used where Colorado generated $250 million of cash, and then from the proceeds of the sale of cannabis, and then they're putting that into their infrastructure, into schools. How's that different than me owning a piece of real estate in the States where I have an income producing piece of property and I'm generating rental income, and that rental income is coming to me from the proceeds of marijuana? How's that poison that I'm I'm receiving cash from that poison sale versus what they're giving to the schools?
Yeah, well, I'm trying to think of the right word, but yes, what's good for one is not necessarily good for the other, and governments aren't eligible for bankruptcy protection.
Yeah, the Controlled Substances Act clearly states that a commercial landlord is not distinguished from a direct participant. I mean, I think that's the.
Yeah, there's no difference, right?
Yeah.
Just one more question. If you're a secured lender, and obviously some of these cannabis grow-ops, they require equipment and things like that. So as a lender, if you're one removed and you're supplying equipment, some of which may be going to the cannabis industry for their operations in Canada, not US, just pure Canada, then they're realizing, obviously, on their accounts receivable, cash collections are coming in. Why do the Canadian banks have such an issue with that money coming in and being deposited into a Canadian account?
Can you repeat the last part of that one? The Canadian banks have an issue with what?
So for example, say I'm lending to a company that provides equipment to a Canadian grow-op, but they also do other industries. Doesn't matter, but they're supplying some equipment to the cannabis industry within Canada.
Yeah.
You're now collecting receivables from that cash collections from that cannabis entity. Why won't more Canadian banks be accepting of being able to set up a Canadian bank account for the secured lender, like say a blocked account or a springing blocked account, where the funds are coming into that blocked account, and the banks are going, we're not dealing with this. So you got to go to the credit unions or whoever, right?
Yeah.
I mean, it's like that's literally like, I don't know if it's like a
Peter, do you have a?
risk.
So if it's just in Canada, you're starting to see the chartered banks come more on side. They are, as Scott said, participating in syndicates. The Roar deal was one. I had BMO participate in a syndicate for a company called Chiron we represent. So we're starting to see that. And they are unofficially, I know TD and BMO are both opening bank accounts for campus companies. So it's starting to change. It's just taken them a long time. Given the cross-border nature of their operations, they're operating in the U.S. They have U.S. companies. It's still federally legal in the U.S.
Exactly.
They were a little more skittish opening accounts here until it became legal a year ago. So they're just taking time, but it's starting to happen.
Thank you very much.
Okay, Aaron, we talked about commercial landlords. What about other services that are not really in the cannabis business but are related to it?
Generally disfavored. Even in states where recreational use is legal, here's District of Colorado, December 2018, Way to Grow, Inc., dismissing gardening supply stores Chapter 11 petition due to the store's marketing and selling equipment to marijuana growers.
They weren't even selling, they had a marketing plan to sell to cannabis players.
The interesting thing is same-sex marriage. The United States Trustee's Office, when that was sort of illegal federally, eventually they took a soft-handed approach and sort of bowed to the states as the states were legalizing same-sex marriage. And that opened up tremendous opportunity for individuals that wanted to access federal bankruptcy protection to do so. And the same could happen here. If you have direction from the top that the U.S. Trustee's Office was going to take a soft approach to allowing cannabis ops or parties sort of in the chain of command to access bankruptcy, you'll probably see a lot more of it. There won't be objections per se from the U.S. Trustee's Office, so that'll eliminate a major barrier. So I do see some softening, and I see courts trying to affect that change. The Ninth Circuit issued an opinion pretty recently which confirmed a Chapter 11 plan of reorganization for a real estate holding company where one of their lessees was in the marijuana grow business. And the court said in that case that the plan was not proposed for means antithetical to applicable law. The plan was proposed for legitimate purposes. Maybe if the objecting party earlier on in the case raised this issue, they might have been able to get some of the relief that's been granted in the other courts, but they waited till a plan was on the table, and the Ninth Circuit came down and said, plan confirmed, we don't care.
Thank you. So if you're a Canadian lender, it's not just marijuana, cannabis, direct activity. You need to be wary of commercial real estate. You need to be wary of this, any other supplies that may impact, that may be supplied to the cannabis business. Let's talk hemp for a minute. And I'm gonna say a few things about hemp. You guys just jump in as you see fit. So we all know hemp was legalized nationally, federally in the U.S. And what legalized means is it was removed, the THC derived from hemp was removed from the Controlled Substances Act. And the THC derived from hemp is less than, by definition, less than 0.3%. And so what you get is a high yield of CBD, which is the medicinal oil that everybody's looking for. So it's been removed, and everybody thinks it's legal, but that's not entirely true, because all that does is it removes the DEA as the regulator and the enforcement arm for hemp-derived CBD, but it just moves over to the FDA, and the FDA has said you can't sell CBD oil from hemp with any health claims, and you can't put it into food anywhere. So. And you've got states with a hodgepodge of different licensing and approvals for CBD oil. So you have very much the same issue going on in hemp as you do in cannabis. Not as bad, but very much the same issue of an incoherent and unreconcilable, if I can put it that way, federal and state laws.
It moved from a controlled substance to a regulated drug. I mean, that's in essence, that's all that's happened.
Well, and all that you're allowed to sell legally is oil.
But the FDA
With no
doesn't
health
regulate
claims.
anything, so it's just moved to a gray zone in the U.S. where people are selling it illegally. They're trying not to make
Correct.
health claims, but eventually it's a huge gray market in the U.S.
Correct. And here's what you need to think about, I think, as a lender, because I know for a fact that there's a couple lenders that I deal with in Toronto, I won't drop any names, and their internal policy is they will lend on hemp deals, but they won't lend on cannabis deals in the U.S. because it's legal. So here's some stats on that. You've got this unreconciled state federal laws going on. You got the FDA saying you can't put it in food products, can't have health claims. There are companies going around the U.S. right now randomly doing testing selection of CBD that's sitting on shelves in gas stations and convenience stores, and none of them pass. They all have too much THC. So What's the reason?
Or zero CBD, from what I've heard, right?
Yeah, exactly. Right. And so what are the causes of that? Well, you have a bunch of bad actors in the industry, right? And so they're creating a CBD, but then they're putting in a synthetic THC on top of that to get the buzz that people are looking for so they can sell more stuff. There is THC in all hemp plants, but it's inactive. And so you could have and most of the hemp in the U.S. is grown outdoors. It's not in controlled greenhouses like the Canadian cannabis market. So you can have, through the miracle of reproduction, a male and a female hemp plant. There could be pollen coming in or whatever into your field, and it could be what the hemp guys call go hot. You could literally have a hemp grow turn into a cannabis grow during its cycle. And if you're lending on what used to be a legal crop in your mind, it could turn into an illegal crop. And then you got to question your security on that.
I think that needs to be said again. Hemp can, through natural causes, convert to, full-blown marijuana
So
cannabis.
a higher THC than
Right.
0.3%.
And particularly in an outdoor growing environment, as opposed to the more regulated environments in a greenhouse.
And the other thing that's not regulated is the processing. So the processing of the hemp oil, of the hemp plant, you're getting out the CBD, but you're also getting THC, and it's the exact same process. And so if you're not processing well, and these things are not well regulated or regulated at all, you can actually get THC into your CBD oil through the processing in a hemp deal. So I'm not saying that hemp is going to be a terrible problem. I just don't think lenders or any professionals in this room ought to be wandering around thinking that hemp's going to be fine and is federally legal, because there are going to be problems coming down the pipe on this.
In the United States, hemp production was legalized by the Farm Bill relatively recently, and hemp growers, hemp producers, anyone in that chain of command, they clearly have access to federal bankruptcy protection. One of our judges in the Northern District of Illinois actually issued an opinion pretty recently, a couple months, effectively saying the same. So at least for now, I don't know if this hot plants,
Query whether
hot hemp is a
whether
boogeyman.
hot hemp whether if the hemp becomes hot, do they become ineligible to be restructured? I mean, if the cause of their insolvency is them having a licensing issue on the hemp because they've gone offside the FDA requirements for THC, do they become ineligible for an 11 or a 7?
Oh God, I don't. That's
Maybe.
oops.
Depends on who gets elected in the next U.S. election.
We're out of time. Thank you, everyone, for attending.
And I want to take a moment and just thank Scott and Aaron and Rick for all of their effort, and you guys for coming up from Chicago. And Scott, I know you put a lot of time into the preparation for this, and thank you for doing so.
Pleasure. Thanks, everyone.